Good afternoon, everyone. Congratulations, you've now completed your first week of essentially online lectures. I presume it's the same for your other classes. You've also successfully completed the test for Chapter 9 last week, again, by way of email exchange, which is what you're used to, but you're now doing it at home or wherever you choose to do them. I can tell you that the class average on the Chapter 9 test was 23 out of 30, which is about 76%, which is, which is a B plus and very close to an A. So that's excellent. So good for you. Again, of course, after this lecture today, then on Wednesday, again, you'll have a online test for this particular chapter, which deals with property law. This is the second last lecture of the semester. Next week, we will have a lecture on intellectual property. And then following that on April 7th at 7 p.m. will be your final exam. I will give you more details of that next week. All right, so what I'm going to do is I'm going to share with you the PowerPoint for Chapter 10 on property law again. All right, so again, you'll have me up in the top right-hand corner of your screen, and you should have the vast majority of your screen being the PowerPoint. So let's start this. Today's lecture will be, should be in the order of about an hour in length. All right, so property, the property itself is a term that has been used over centuries, essentially, to describe what are relationships between parties with respect to their interests in what are considered tangible and intangible things. So property itself is not the thing that you think it is. So when we refer to property being a chair or a desk or a house, right, while we're referring to that particular thing as being property, the real law dealing with the property is not that it's the thing itself, but it's the relationship with respect to who has whatever their interests are going to be in that thing. But having said that, for all intents and purposes, we'll still refer to property as being things because that's what you understand them to be. And it's obviously much easier to follow if we use that simple understanding. So there are two major forms of property. We have personal property and we have real property. So real property is exactly what you would think it is. It's like real estate. It refers to lands and things that are called fixtures attached to those lands. I'm going to describe that in a few minutes. All right, so that's real property is essentially real estate for the most part. So that's easy to understand. Personal property, on the other hand, is what's considered to be movable property. So your laptop or your phone or your books or your TV, all those kind of things that you can actually pick up and move. That is personal property. And in addition to movable property, we have what are things that are called choses in action, and I'll describe to you what those are. So you either have movable property, which are chattels, and other types of personal property that are called choses in action, right? So this is a chart setting out the types of property that can be described under these headings. So real property has the list, which is land, and then buildings attached to land, garages attached to land, fences, bridges, and again, fixtures. All of these things are attached to land. And I'll explain to you what the significance of the attachment is very shortly. Personal property, again, are either chattels. Again, these are cars and furniture, and computers, office supplies, what have you. Or choses in action, which are shares in corporations, checks, and promissory notes. Right? And then we have, lastly, intellectual property, which is a form of personal property, and this deals with things like copyrights and trademarks, patents, and what have you. That is going to be the subject of the entire lecture next week, intellectual property. Okay, so let's deal with personal property firstly. So things that are tangible, that have substance and form, are called chattels. Right? So these are terms that you need to know. So chattels are, in fact, tangible personal property. So there you go. So cattle are chattels, just as an example. All right. Non-tangible personal property basically comes in the form of, and this is goes to the actual definition of what property is. Non-tangible personal property deals with the rights or claims that one person has to another, right? And these include things like checks and stocks and bonds and other negotiable instruments, which are called choses in action. So what that simply means is, for instance, if you write a check to somebody, which obviously represents the exchange of money, right? So the check itself isn't actual money, but it represents money. And when somebody gives a check to somebody else, they're giving that person who receives the check the right to collect money from the person who writes it. It also gives them the right that if the check bounces, which means, of course, that the bank doesn't honor it, we talked about this last class or 2 classes ago, if the check isn't honored by the bank, then the person who's received it is given rights to go after the person who wrote the check to essentially sue them for the money that's owed, that's represented in the amount shown on the check. Okay, so that's a personal property kind of thing, but it's not tangible. You can't pick it up and carry it, as in you can't pick up and carry the money it represents. You just have a check that represents that money, right? Same thing with stocks and bonds. They represent an ownership interest, for instance, in a company. We talked about that in a previous class. So you don't actually, when you pick up or have in your hands a stock or a bond, you don't actually have a piece of the company in your hands, but you have a piece of paper that represents your percentage share in that company. In the company obviously being the buildings in which it carries on its business, the inventory that it may generate for the purposes of sales, all those kind of things. All right. Again, intellectual property, which is copyrights, trademarks, and what have you, that's a specific form of a chosen action, which again is a type of personal property. Okay, so back to this thing called fixtures. Fixtures are basically tangible and movable property, right? So at this point, it's personal property, but what in fact differentiates it from personal property is that it's affixed to real property. All right, so fixtures, just like it sounds, fixtures are personal property that are fixed to real estate. And as a function of being fixed to real estate, they actually become part of the real estate. So they lose their classification of being a tangible piece of personal property. So if you think of a furnace in a house, so for those of you who live in houses in the Sioux, I guarantee you that somewhere in the house, most likely the basement, unless the house doesn't have a basement, but houses in the Sioux all have furnaces because we live in a cold weather environment for a great number of months a year. And these furnaces, in fact, are screwed, basically have bolts in them to the cement floor or whatever the flooring is, in the house itself. So once it is bolted to the floor in a house, it becomes part of that house. So therefore, that house, which we know is real estate, right, now has a fixture forming part of that real estate. Fixtures, however, used in the course of a business, and this is things like heavy-duty machinery in factories. So, for instance, Algoma Steel has, a number of very large pieces of machinery in a factory. They're considered what are called trade fixtures, which are treated differently than other kinds of fixtures. In that, trade fixtures, which serve a purpose, obviously, of generating income for a business. Most trade fixtures, if they are in a location that is being rented, for instance, by a tenant carrying on a business. So, somebody owns a large factory shell, we'll say, and they have a tenant who pays rent to be using that shell, and they bring with them their own large pieces of machinery, even though those pieces of machinery are bolted into the floor of the factory. The tenants who bring them with them for the purposes of carrying on business will have the right, almost inevitably in every commercial lease, they'll have the right to, in fact, when their tenancy terminates, to basically unbolt the machinery from the floor and take the machinery with them to their next location, in which again they'll probably refix them to a new piece of real estate. Right. So having said that, apart from trade fixtures, most other fixtures stay with the property unless agreed to otherwise. Uh, and there are lots of instances where, in fact, agreements are made otherwise. So, for instance, in most agreements of purchase and sale, when somebody is buying a house, the vendor or the seller of that house will almost invariably put in the agreement of purchase and sale that there are certain things that are fixtures that they are going to want to unattach from the walls or the floors and take with them. So that could be mirrors on walls, it could be wall-mounted television brackets, those kind of things. Anything that, and it could be chandeliers. Anything you can think of that perhaps somebody would attach to a ceiling or a house or a wall or a floor in a house that they want to take with them, then as long as those items are specifically set out in the agreement of purchase and sale that the seller wants to take them with them, as long as they are therefore set out in the contract, then they can take them with them. If they don't set out these things, the mirrors and the television brackets and what have you, if they don't put those in the agreement of purchase and sale, then they remain as fixtures and then they become the property of the purchaser when the closing of the house transaction takes place. Right? Titles to goods and chattels can also be transferred by way of a gift. We talked about this in some detail in the law of contract class. Right? So gifts, obviously everybody knows what they are. Gifts involve the voluntary transfer of the ownership in something to somebody without there necessarily being any consideration flowing back to the person giving the gift. As soon as the delivery of the good or chattel, that is the gift, is actually handed over to the person who you want to receive that gift, then the ownership in the item being the subject of the gift is complete. And so in fact, the person who receives the gift now owns that particular piece of personal property. If someone makes a promise to give a gift in the future, then the person promising to give that gift can change their mind any time up to and including the time of delivery. So if I promise to give you a mink coat on next Saturday, right, and that's a nice kind of gift, I don't even know whether anybody has mink coats anymore, but anyway, if they do, and I promise to do that, having said that, if I change my mind up to the point where I actually would have done it on next Saturday, I'm basically not delivering on that gift, but I have the right to do that. So that's that's the law of gifts most particularly. You can also have what's called constructive delivery of gifts and or any property really that may well be too large to hand over to somebody. Remember again, personal property is tangible, movable property, but you can do it constructively if, for instance, you give somebody the keys to a car. So that, that represents the delivery of the gift. So the keys change hands, then the person receiving the keys now owns the car. So that's how that works, all right? Title to goods can be transferred by what's called a chattel. Again, that's a tangible piece of movable property in writing under a seal. Right? The affixing of the seal is crucial, and everybody knows why that is. That represents, in fact, the consideration in the transfer, and basically, is there in the event that there isn't any other thing of value apart from the seal itself. Once a deed is signed and sealed and handed to the purchaser, the transfer of the ownership is complete, right? So that's important to keep in mind for personal property, right? And then more particularly with respect to a chose in action, again, these are things like somebody owes a debt, which could be represented again in a check or a bank account and stocks and bonds. They can be transferred as well, which simply means that, for instance, if you give me a check for $100 for some purpose, you're buying something from me and you give me a check for $100, I can transfer my ownership in that check to a third party. So you give me a check, and for whatever reason I want to give it to a third party because maybe I owe them money, or I want to give it to them as a gift. That's certainly possible. Then what I do is I endorse the back of the check and I give it to the third party. And as a function of that, the ownership interest in that, what's considered to be a negotiable instrument, has been transferred. Exactly the same thing for stocks and bonds, again, which represent an ownership interest in a company. If I have a stock or bond, I can transfer that to a third party, and they in fact become the owner of whatever that stock and bond represents as the interest in a company, all right? In order for, however, these transfers of negotiable instruments to be effective, then what I have to do as the person who transfers it, or the person who receives it, the third party. What has to happen is that the person who is obliged pursuant to that negotiable instrument has to be given notice that the ownership interest has changed hands. So if you write me a check and I give it to a third party, either I or the person I give the check to has to notify you that the check is now being held by the third party. Okay, the law of bailment. So the law of bailment is a very specialized kind of law that deals with personal property, but it's incredibly important because bailments take place pretty much in everyday business activity. So when the owners of a good or chattel allow someone else to possess it, that's considered what's called a bailment. So a bailment is an old English term, so you need to be familiar with this term. So the obligations that exist from the person who receives the good, that's the bailee. So if I give you a piece of art, for instance, to hang on to for my benefit, because you are in the business of providing security for valuable art, I'm giving you this piece of art for you to hold and protect. So the person I give that to is called the bailee, and the person who's giving over that piece of art is considered to be the bailor. Okay, so bailor gives personal property to somebody else, bailee usually for a very specific purpose, and almost always for a purpose involving money if it's a commercial bailment, which obviously is important for our class. So, and the more consideration that is given to the bailee for looking after goods, correspondingly that increases the level of care that the bailee has to provide with respect to that particular piece of property, personal property. All right. So if a bailee is simply holding on to a piece of property, a chattel, as a favor to a bailor, so that's usually not the case in a business transaction. It can be, but this is more common in personal bailments. But no matter what the environment is with respect to the holding of the good, if it's done gratuitously without any payment changing hands, then the bailee is only responsible if damage happens to this good or chattel if it's caused by being willfully reckless or fraudulent. So that's a very high standard. So which basically means that a very low level of care is imposed upon the bailee. However, a bailee who is paid to look after a good or chattel, and again, this is much more prevalent in business transactions. So a bailee who's responsible, is now responsible to take care of the good or chattel that is the subject of the bailment to a level of at least equal to negligence. All right. So in fact, they don't have to, if they're being paid, right, you don't have to prove they were willfully reckless or fraudulent. You only have to prove that they were negligent in taking care of the good or chattel that you've entrusted to them. Right. When there's monetary compensation for bailments in commercial premises, we have usually what's put in place is what's called an exculpatory clause that now limits the liability of the bailees. So remember that in normal circumstances, bailees are only responsible for goods if they're being paid to the level of negligence. However, if a business who is in the business of taking care of goods and chattels on behalf of people who pay them for that purpose, then it's no longer negligence. In fact, what they're going to be responsible for is the following. So if a restaurant, a theater, or other venue has a coat check room, and they almost all do, so the Royal Alexandra Theatre in Toronto, which produces plays. Normally, they're all closed nowadays, as everybody would realize. But in the normal course of the event, when you're going to watch a play, you come in and you don't want to basically be wearing your coat, particularly in the winter, while the play is going on. So you hand it over to somebody in a coat check room. You pay for that, basically for them taking care of your coat while you're in the play. And so, in this context, what almost everybody does who's in the business of these kind of things, coat checks, they post a sign on the wall. And they post a sign on the wall. This is within the coat check room that says this: take notice, we are essentially not responsible for lost or stolen property, which means the coat you've handed over to them in the coat check. And then, beyond this sign, and this is a function of the common law, case law over centuries, has also basically said that the sign also has to say this: that we're not responsible for lost or stolen property, however caused. Those are just two words that have to be on the sign. And as long as the sign says that, and as long as the sign is in plain sight, so for instance, in a coat check, it can't be on a wall that you can't readily see when you're looking into the coat check room. So as long as the sign is clearly, basically there to be seen, then the level of negligence is, back up to grossly reckless or fraudulent. Now, common carriers such as trucks and buses and railways that again carry goods of people who basically who pay them to do so. They again have a very high duty to take care of the goods of their customers, basically, and that duty arises even if there isn't negligence. So this is the lowest level of care that basically is available. So if you're paying a common carrier to carry something of importance of yours from Toronto to Vancouver on a train, then if something happens to it, the common carriers are responsible to it pretty much no matter how it's caused, right? So that you don't have to prove that they were negligent, and you certainly don't have to prove that they were grossly reckless or fraudulent in their handing of the goods, okay? On the other hand, hotels, motels, beds and breakfasts, Airbnb for that matter, actually have that same sort of liability as do common carriers, because again, these are business premises that are being paid for the purposes of having your goods on those premises. So if you're a guest in a hotel, this would be or any of these venues, it would be your luggage for the most part. So while they have the same liability at common law as common carriers, which means that they're responsible pretty much for any damage that may happen to your luggage, what's happened is that legislation has entered into the field of these kind of bailments by virtue of the Innkeepers Act, Revised Statutes of Ontario 1990. And what this piece of legislation basically says is that they now have a higher level of care that that has to be proven before they will be liable for any loss or damage, which means the Innkeepers Act has given them, has differentiated them from common carriers, raised their level of care from being responsible for any kind of harm to only harm that's caused by that of negligence, right? So we have those three levels of care that are relevant for bailments, all determined by A, whether there's monetary consideration for the bailments, and B, the particular kind of business the bailee is in. Okay, so let's deal with real property. The law of real property is very well established. It's been, obviously in place for centuries and centuries, because, society as a whole sees the ownership of real property as extremely important, both for society and for individuals in society who would like to own that real property. It's likely to be the biggest asset any of us, you and me and whoever, may well ever own for the most part, right? So in fact, it's incredibly important. There are two kinds of interests. Again, remember that property is really the relationship between individuals with respect to a thing which we consider to be property. So there are two kinds of those relationships that are important in dealing with real property, what are called freehold estates and leasehold estates. And freehold estates essentially deal with the ownership of property. All right, so if you and or your parents own a house in Sault Ste. Marie, they have a freehold estate interest in that house. But everybody just considers that to be an ownership interest. When you own your house, you're really referring to a freehold estate. And what that essentially means is that there is no terminal date of the ownership interest in the house, which means that when you own it, right, a freehold estate does not have a date that says that your ownership will come to an end on January the 1st, 2021. That's not the way that ownership works. You own it until you sell it, or you own it until you die, potentially. But even when you die, the ownership interest is still available to you through your estate to whomever you leave it to as a function of a will, or if you don't have a will, however it is to be transferred according to what's referred to as the Succession Law Reform Act, for those people who don't have wills. But that's beyond this lecture. Freehold estates are real estate. The other kind of interest in real estate we have are what are called leasehold estates, which deals with the leasing or rental of property. So lease is in the actual term itself. So leasehold estates deal with tenancies, right? And tenancies are something that you are likely all familiar with because you very much likely have a tenancy where you are living in Sault Ste. Marie. If you're living in residence, you have a tenancy agreement as a function of the right to be on the property of the university. So you're living in residence, that's a tenancy agreement. Or if you're living or you're renting a room or part of a house or an apartment in Sault Ste. Marie, then you have a lease or tenancy agreement for that purpose. Tenancy agreements can be made without a lease, so you don't have to have a written contract for a lease, unless your intention is to be there for a period longer than a year. Then you're going to need, or sorry, 3 years. Then you're going to have a lease. So if you don't have a lease, what you have is what's considered to be a periodic tenancy that runs from month to month. Okay. Most tenants, when they enter into a lease for an apartment or a room, what have you, have what are called fixed term leases, and those are put in place by way of written leases, and these will have terms that come to an end. So you will have, in fact, a lease for 12 months. That's the most common type of lease you're going to have. Perhaps because you're students, if you can negotiate a lease for 8 months, the academic year from September to the end of April, then that is possible, but that's likely only possible if you're only renting a room, okay? During anybody's tenancy, the tenant, you have the exclusive rights to possession of the premises. So whatever is the area in a house or an apartment to which you're renting, you have the exclusive right to have, the sole occupancy of that particular premise. And as a function of that, landlords can't at will come into your premises even though they own them. Your tenancy supersedes that ownership interest with respect to possession. So most leases will have a provision in it that says that the landlords have the right to enter your premises on some fixed period of time, providing notice. So it's either going to be, for instance, 24 hours or 48 hours. So your lease will say that the tenant or the landlord can give you notice that they're going to come into your apartment after 48 hours. And they can do that just simply to inspect it for its cleanliness and particularly to make sure there's been no damage caused. Any number of reasons are available for that kind of notice. Leasehold interests, again, tenancies, they do this. They what's called run with the land, and that's a very distinctive phrase in the law of property, which simply means this, that whatever leasehold interest happens to apply to a piece of real estate, right, that the original landlord, basically who's entered into that lease, basically passes along that interest in the lease to anybody who may well buy that piece of real estate. So if I own a house and I have, say one of you rents the basement apartment I have in the house, and our lease is for a year, and then 6 months into the lease, I decide to sell it to somebody else, and I sell it in the 7th month of the lease, then whoever I've sold the house to basically has to accept the remainder of the lease, the remaining 5 months of the lease with you as a tenant in the basement apartment. So leases, again, run with the land. That's what it's called. Okay. All tenancy arrangements with or without a lease have an obligation for a tenant to pay rent on a regular basis as agreed upon, and to repair any damage that takes place within the leasehold premises beyond normal wear and tear. I'm sure you're all familiar with that. The Ontario Residential Tenancies Act, which was put in place in 2006 by the province of Ontario, sets out in detail now the rights and responsibilities between landlords and tenants in residential settings. So again, it's residential tenancies, doesn't deal with commercial tenancies. So what the Act sets out are things like rent controls, which basically means that the landlords can only raise your rent for a fixed term or a fixed amount determined by the province of Ontario on an annualized basis. And the current allowable raise in tenancy rents is about 2.1% by the province. So, if you're going to be in a tenancy for more than a year, then you can expect the rent to go up by that amount, but landlords have to give the tenants 90 days notice before that increase takes place. So that's something that you would hear from your landlord in October if your lease renews in January, kind of thing. The Act also sets out provisions dealing with how to terminate tenancies for various lengths. So almost all fixed term tenancies that are residential and month-to-month tenancies require the landlord to give at least 60 days notice before they can terminate a tenancy. And likewise, you as tenants have to give your landlords 60 days notice before you leave the tenancy. There are shorter terms in particular circumstances dealing with, again, rental of rooms usually has terms that require only a 30-day notice. That's particular to whatever arrangement you have with the landlord. There are also reasons that the Act sets out as to how, or the reasons why a landlord can give notice. Obviously, the most common notice that a landlord can give to terminate a tenancy is that the tenants are not paying rent, right? But having said that, the Ontario government this past week, Premier Doug Ford has gone public and said that during this period of self-isolation and obviously a lot of people without work now as a function of what policies are put in place to control or contain COVID-19, that nobody is going to be evicted as a function of these provisions being put in place. So in order for that to be effective, the Ontario government is going to have to amend the Residential Tenancies Act dealing with reasons to or not to evict tenants. So that's where that's where Ford is going to put the provisions into place, right? Other ways that tenants can terminate tenancies, and I doubt very much whether he's going to address this in legislation. For instance, if a landlord wants the premises for a member of their own family to occupy it, then that is a reason to terminate. Or if the landlord wants to do such extensive improvements, capital improvements, essentially, to a leasehold premise, then that would basically require the tenant to move out. Then landlords can do that for that purpose if it's legitimate, right? And a lot of people have complained that basically a landlord saying that you have to move out because I'm going to renovate is not a legitimate reason. So if you want to contest that as a tenant, basically you go before the landlord and tenant board, which is a tribunal that looks after these things, and make your argument that whatever eviction notice you've received is not valid. All right, let's deal with the ownership of real property now. So that was leasehold. So now we're going to real property. There are two fundamental or basic ways that more than one person can own real property. The two ways are what are called a tenancy in common or a joint tenancy. Don't let the word tenancy confuse you. Tenancy in this context of real estate does not relate to leasehold. We're dealing with freehold, all right? So a tenancy in common is an arrangement whereby more than one person or parties can own real estate, and they can own a percentage in that real estate, but it's what's called a percentage ownership on an undivided basis. And what that simply means is that a number of people can own a parcel of land, or it can be a house, whatever the real estate is, and they can own 25% of it each if there's 4 of them, or one can own 50% and 2 can own 25. You can mix and match the percentage any which way you want, but they don't. For instance, if you own a 50% interest in that parcel of land, it's not that you own the left half of that property of land, or you own the house and everybody else owns the land around it, which would be a divided basis. What you own is a 1/2 interest in the whole of the parcel, all the land and the house kind of thing. So you may have a 50% ownership, but it's in all of it. You may have a 25% ownership. It's in all of it, right? So that's undivided. That's incredibly important to keep that in mind when you're talking about tenancies in common. And the really important point about tenancies in common is that if a party who has that kind of interest in real estate dies, then their interest in that undivided parcel goes to their estate. So they can leave their 50% or their 25% interest to whoever they want to do so in their wills, or again, if they don't have a will, it's going to be pursuant to the Succession Law Reform Act. Right, so that's important to keep in mind. So if you want to own a piece of property and you want the availability to transfer that that interest to somebody, particularly when you pass away, then a tenancy in common is what you're going to want to do. The far more common way to own houses, right, usually matrimonial homes, is by way of what's called a joint tenancy. And the joint tenancy has, importantly, what's called the right of survivorship. So contrast this with a tenancy in common. So a joint tenancy basically means that if one of the joint tenants dies during the term of the joint tenancy, then it goes to what's called the surviving joint tenant. So this is almost always the way that husbands and wives own property, which simply means this. A husband and wife will, and it could be common law spouses or could be married spouses, if they both put their names on a deed as joint tenants. If one of them passes away, then the surviving joint tenant owns it all. Okay, so you can't, in a joint tenancy, you can't transfer your undivided interest to somebody else, or you can't leave it to somebody else in your will. It automatically goes to whoever is that surviving joint tenant. Having said that, however, if for whatever reason you want to change that relationship, you want to in fact create a tenancy in common from a joint tenancy, then you can do it a number of ways. So for instance, if a joint tenant wants to transfer their interest and have it become a tenancy in common, they can in fact execute a new deed, basically saying that I am transferring my interest as a joint tenant to, and you can do it actually to yourself for that matter, or anybody else. But if you want to do it for yourself, you just simply want to change the ownership structure, but the parties don't change. You can execute a deed to yourself for that undivided 1/2 interest as a joint tenant, and it therefore becomes a joint tenancy, which then means, of course, that you can then subsequently transfer that what's now a tenancy in common interest to somebody else, or leave it to whoever you like in your will. Right? It can also be severed between the parties themselves. So while you can do it on your own by a deed to yourself or somebody else, both parties, and it's usually a husband and wife, but it could be others, but both parties can enter into a new deed between them, basically saying that we agree that our interests are no longer as joint tenants. We agree that our interests together are tenants in common. Okay, so that's what's called severing the joint tenancy. Okay, let's talk about the conveyancing of real property. So this is the transfer of real property. So again, and we talked about this in some detail in our class on contract law, an agreement to sell property must always be in writing. That's provision of Section 4 of the Statute of Frauds, which is a piece of legislation in the province of Ontario. All provinces and territories in Canada have this provision. This provision comes from England, obviously, and it was originally enacted in England in the 1600s. So it's been around for a very long period of time. So all this simply says is, if you're going to deal with real estate, if you're going to enter in an agreement to sell it, or you're going to actually sell it by way of a transfer, it has to be in writing. The most important thing with respect to the transfer of real property is whether in fact the owner of the real property can transfer the title to it to you or to whoever is buying it, and give what's called a good and clear title. That's incredibly important, because if you're buying a piece of real estate, you want to make sure that what you're getting is what you in fact expect to get, which is a good and clear title. Right? The original system that we had basically in all common law jurisdictions is a system that's called the registry system. All counties and districts in Ontario have a registry office. So the District of Algoma's registry office happens to be here in Sault Ste. Marie, and it's in the Service Ontario premises. I think it's 430 or 428 Queen Street West. You guys all know it. It's next to the courthouse. So that's the Service Ontario office. And within that Service Ontario office, there's a good chunk of it actually set aside as what's called the registry office. Right, and in that registry office, and obviously in storage behind the office premises themselves, there are what are called abstract books, which are books that actually, and they're in hard copy, have recorded every transaction. So that's going to be a transfer, a deed, it could be a mortgage, it could be a lien for some sort, anything that would be registered on title. Abstract books have a record of them together with the original document that created whatever that instrument was on title. So all of those original documents are on the premises of the registry office, and they go back to the Crown grant. So the Crown grant, for most of Canada, was basically when the federal government, originally the British colonial government, acquired the lands as a function of treaties with those who have now become members of First Nations, right, who entered into those treaties. So in Sault Ste. Marie, we are a treaty people for the Robinson-Huron Treaty, which was entered into in 1850. And as a function of that, if you go to the abstract for the piece of property you're looking to buy in the registry system, you can find all of the transfers of title and all the mortgages that have ever existed back to at least 1850 in this particular territory in which we reside. All right, so that's the registry system, and and as a function of that, again, you can look at all of these original documents. You can actually pull them and hold them in your hands. And obviously, some of these are going to be hundreds of years old, so that's available to you if you want to do that. In this system, if you are going to ensure that you have a good and clear title, then the statutory law applying to searching titles basically indicates that you have to search the title going back at least 40 years prior to the date of purchase of your property. So you're going to go to the registry office, you're going to pull out the abstract book, which basically has a page dedicated to the parcel you intend to have an interest in. Buying a house, for instance, they all have a separate page in a parcel. And that page will basically show you all the interest and title going back again to the Crown grant. But all you have to do to have a good title is to go back 40 years. And the theory behind that is that anybody who has an interest in property who wants to make sure that interest is protected, is certainly going to ensure that it's been there, within the last 40-year period of time. If it's older than 40 years, then that interest is lost because nobody's required to search further back than that particular time frame. And having said that, so again, the purchaser is required to look at the abstracted title and look at all instruments on it over 40 years from the time of the purchase. And the whole purpose of this, again, is to see if in fact there's going to be a good and clear title. And what you're doing when you're looking for that kind of title is you're looking for anything on title that would create what's called a cloud on the title. This is not a cloud as in, basically we're recording everything in the cloud for the purposes of storage of, electronic transmissions, what have you, or internet transmissions. That's not the cloud we're talking about. We're talking a cloud as in something that muddies the title, all right? It is the purchaser's responsibility to ensure that the title is good. So if I enter into an agreement of purchase and sale with a vendor to close the purchase of a house at the end of April, then it's my obligation to in fact search the title to make sure that it's good, so that I'm looking to make sure that there are no clouds on the title. Traditionally, this job is done by lawyers, so very, very few people would ever put their trust in anybody else other than a lawyer to search a title when they're buying a house to ensure that they're getting a good title with no clouds. So a cloud would be an older mortgage that, for instance, should have been discharged when property changed hands in the past, but wasn't, right? So that's a cloud on title. Or a lien that somebody put on title, right, that obviously is not supposed to be there when somebody is trying to transfer a good title. So it's a function of hiring a lawyer to basically look at that title to make sure it's a good title. What the lawyer does is they do that, and then they certify the title to the clients. So they basically, their obligation is to whoever hires them to search a title to in fact look at all the instruments in the registry system that goes back 40 years and basically certify to a purchaser that in fact there are no clouds on title. So a good and clear title can be transferred. If the lawyer makes a mistake in doing so, and there's a cloud on title that they didn't catch when they looked at all these instruments going back 40 years, right, then the purchaser, when that mistake comes to their knowledge, which is usually when they're going to sell the property and somebody else searches it and they find this cloud that should have been found beforehand, they can sue the lawyer. Lawyers have indemnity insurance for this kind of thing until the registry system change, which I'm going to describe to you in a few seconds. Before the change in the registry system, where lawyers were responsible to certifying title, this was the largest area of negligence law with respect to lawyers practicing pretty much anywhere in the common law world. Right? More mistakes take place in providing good title than, for instance, lawyers acting in motor vehicle accidents or matrimonial matters or criminal matters. This was far and away where most mistakes were made. As a function of that, basically what happened over the course of not that long ago, it became clear that there must be a better way to do this, to actually look at someone's title other than going back over that 40-year traditional period of time. So what happened is that governments, so these are provincial governments because they have responsibilities under Section 92 of the Constitution over land, that's a provincial responsibility. So provincial governments started to put in place systems where, in fact, instead of lawyers guaranteeing titles to their clients, the governments would, in fact, guarantee title. So they would guarantee the reliability of title. And what this became called was the land titles system. That's what it's called in Ontario. It has different names in other jurisdictions. For example, it's called the Torrens system. In Australia, it's called the Torrens system, but we call it land titles system. So this is a new method. It's been in place now for about 20 years. It's been in place now to replace the whole requirement that somebody has to search a title for 40 years. So what happens now is, again, you can go to the registry office in Service Ontario to look at this, or you can do it now from your desk, in your office for the most part, or your home if you're going to do it yourself. But again, almost everybody still hires a lawyer to do this because there is some very specific software that lawyers have access to with respect to the land title system that isn't available to anybody else. So lawyers like to have a bit of a monopoly when it comes to this kind of thing. So what happens is that when you go online, you search for the parcel description for the house you are buying, or somebody is buying, and up will come on the screen basically just, and this is guaranteed by the government, who is in fact the owner of that parcel, and if there are any mortgages or liens against it that are still outstanding. So that just saved you the time of doing all of that work over a 40-year period to come up with those particular bits of information. Right? And so what happens is the government land titles now, they indicate all the instruments that affect the ownership. They enclose that in what's called a certificate of title. And as a function of that, if you are entitled, so this is most often lawyers who search these databases, you basically pass them along to purchasers as their title. The government now guarantees the good and clear title to properties, at least what's shown up on the register in the land title system. So again, a lawyer will see this. If a lawyer sees that there are 2 mortgages in place, and that's certainly possible these days with houses, then they would notify the lawyer for the seller of the property, you must discharge these 2 mortgages when you transfer this property from your client to my client. So transfer the property from the seller to the purchaser. So that's exactly the process that takes place. And again, this is now the way it's done throughout Ontario. Okay. Real estate can also be used, and this is obviously very important in the business context, can be used for the purposes of raising money. It is, again, a substantial asset. If somebody is borrowing against real estate, what they're doing is they're basically entering into a transaction with what is called a mortgage. So the mortgage is the Old English term for security in real estate. Obviously, it's something that you should be familiar with. However, mortgages in the land title system are now called charges. So, but they're exactly the same thing, a mortgage or a charge, okay? Most people who buy houses need mortgages to buy them. So if I was to go out into Sault Ste. Marie and buy what I think is a nice 3-bedroom home, that's likely going to cost anywhere between $200,000 and $300,000. That's probably the range. If I find one that I want, unless I have that kind of money in cash, I don't. So I'm going to go to a bank or a credit union basically and say, can you help me with the purchase of this house? I need a mortgage for whatever amount of money I can't come up with on my own. And if my credit is good and they're satisfied that my income is sufficient to be able to make mortgage payments on time, then they'll give me a mortgage. So if I'm buying a house for $250,000 and I happen to have 20% of that as a down payment, which I require in Canada, unless I want the mortgage to be insured, and that's a whole different story. So if I just want a very straightforward mortgage on conventional terms, I have to have at least $50,000 for a $250,000 home, and I will get a mortgage for $200,000, right, on the terms to whatever I agree to that the bank provides me. Right. Again, in businesses, businesses also mortgage their properties for the purposes of raising capital to carry on the business of making profit. In a mortgage transaction, the person who borrows money, or the company for that matter, who borrows money on a mortgage, is called the mortgagor, or technically the chargor in land titles. And the person who basically is giving up the interest in their real estate, which means providing security for that mortgage, is called the mortgagee, right? So what essentially that means is that the person who lends money is the mortgagor, the person who borrows money is the mortgagee. Oh, it's the other way around, I apologize. The person who borrows the money is the mortgagor, the person who lends it is the mortgagee. I'm sorry about that, okay. So a mortgage transfers the ownership of the title to the property to the mortgagee during the period of the mortgage. Okay, so that's important to realize that if somebody is going to give up a mortgage, they're essentially transferring the vast majority of their title in the property while that mortgage is still outstanding. When the debt is repaid and the mortgage is discharged, then what happens is that a discharge of the mortgage is registered on title, and what that does is it reconveys back the interest in the property that was covered by that mortgage back to the mortgagor. Right? So what used to happen when people had mortgages, the standard term for a very long period of time has been 25 years, although banks now will give you a mortgage for 10, 15, 25, and I think sometimes 30 years. That means that's the term of the mortgage that you basically have to pay it off. It's called the amortization period, which will determine the amount of your monthly payments or bi-weekly payments, whatever you agree to. But when the mortgage is paid off, and this was more common in generations before me, for the most part, my parents, those kind of things, people would have the same mortgage on their house for the entire term of the mortgage of 25 years. And after the mortgage was paid on a regular basis without default for 25 years, then people would have what are called mortgage burning ceremonies, where they would actually take out that piece of paper. And remember, that piece of paper is a chosen action because it represents money or security for money. They would take out that mortgage itself, that piece of paper, and they would burn it. So they'd have these parties to basically say, we're mortgage free. We no longer have to make monthly payments on our home. All right. This also leads us to what's called the equity of redemption. Right. And this is something that takes place in all real estate transactions that involve mortgages. So what the equity of redemption in legal terms is the legal right of the mortgagor, that's the person who owns the property. It's the right that they have in their property that isn't, basically subject to the mortgage debt. And we're talking about now values of property. So we're talking about the difference between the value of a piece of property and the mortgage debt. So again, if I buy a house for $250,000 and I have a mortgage for $200,000, then that $50,000 is considered to be my equity of redemption, but that's almost always simply referred to as your equity, right? So your equity in a piece of property is just quite simply the difference in value between whatever debt is owed against it and whatever the value of the property is. So, if you own a piece of property for a good number of years, and in traditional terms, properties tend to rise over time in value, and your mortgage debt will decrease over time in value, then if I have a mortgage for 10 years, essentially my equity will be a combination of how much my property has risen in value, that's the market value, and the chances are it will have gone up, and likewise the converse reduction in my mortgage debt. Right, so my mortgage debt may have gone over 10 years from $200,000 down to $125,000. So I've paid off $75,000 in debt, and the value of my property may have risen to say it's worth $350,000 after 10 years, right? So the equity now, instead of that original 50, is the difference between that 125 in mortgage debt and that $300,000 in then becomes the current value of the property, which is in real terms becomes $175,000. So that's the increase in my equity over time. That equity can also be used to create more debt, in addition to that first mortgage that's in place. So you can, for instance, get a line of credit with a bank or your credit union. If it's a relatively small line of credit, which is usually up to $20,000 kind of thing, you can likely get a line of credit with your financial institution without providing security against your real estate. But if you want a line of credit for, say, $30,000, $40,000, $50,000, you may want to just have it there to help with normal expenses, or you may want to build a deck onto your house or renovate your kitchen, any of those kind of things. If you want a line of credit that requires security, then you're going to basically be registering the amount of that line of credit onto your title. And when you do that, it takes on the status of another mortgage. So even though banks will call lines of credit exactly that, lines of credit, they'll further call them what are called secured lines of credit, and that security is another mortgage. So you're going to have both a first mortgage and a second mortgage if you have that kind of further debt on your property. You can have a third mortgage, a fourth mortgage, any number of mortgages that a bank would give you, but they usually don't give you more than a second mortgage. But people personally can do that for you. Family can lend you money and take a third mortgage. That's perfectly fine. But remember, if they do that, it is another registered instrument on your title. So when you go to sell your house, when you look at that part, or your lawyer looks at that parcel index, again, in the land title system, your ownership, the deed that you had obtained your title to is shown on that land titles document, and together with your first mortgage, and then any other mortgages that you may have put on title as a function of raising more money by way of things like lines of credit. So there you go. If there's a default in payment of a mortgage debt, there are a number of remedies that mortgagees have as a function of their security. These remedies are set out in, again, a piece of Ontario legislation called the Mortgages Act. So what a lender, a mortgagee, can do with respect to a mortgage is that they can essentially sell your property. That is their ultimate security in having a mortgage on property, and they can do it by way of three fundamental ways. They can do it under what's called a private power of sale, which is contained in the mortgage document itself, and we'll go through that. They can do it with what's called a court order pursuant to a judicial sale. And lastly, they can actually obtain, instead of selling the property, they can actually obtain the title. They become the owner of the property by way of what's called a foreclosure. Right? And that's a very old and well-known term. All right, so with respect to the first option for a power of sale, so what happens is that the lender exercises their rights under the mortgage to a power of sale, which simply means that giving the appropriate periods of time that they give to the mortgagor to pay them back. If they don't meet those time periods for that purpose, then the property can be sold by the mortgagee. And these time frames are this. So in a power sale proceeding, there has to be default of at least 15 days in a payment. So if you make your regular mortgage payments on the 1st of each month, and say in this past March the 1st, you didn't make your payment, then as at March the 16th, 15 days later, your mortgagee now has the right to give you a notice that they're going to sell your property. And the notice basically says that the 15 days is now gone by. I'm going to give you another 35 days to bring your mortgage into good standing. And if you don't do that within 35 days, then I have the right to put your house up for sale. I have the right to gain possession of the house and sell it to a third party, right? But it's a power of sale, which means mortgagees don't own the property or get the opportunity to own the property. They only get the right to, in fact, sell it, out of your hands, essentially, because you've defaulted in the mortgage. There's also what's called a judicial sale, which is very similar to a power sale, but what happens is that a mortgagee can take a sale property and put it into the hands of a court to exercise that sale. So it doesn't have quite the same time frame provisions, but you will be sued as the mortgagor with an action basically setting out that the court is going to conduct what's called a judicial sale. This is really only used if a title is very complicated and the mortgagee wants the benefit of a court order basically clarifying the title for the purposes of a sale. It's hardly ever used. Power of sale, with private power of sale, is the most common way to enforce a mortgage debt. And that leads us to the last remedy, which is a foreclosure action, which again is a court action. And what this does, and again, this is both pursuant to the terms of a mortgage and the Mortgages Act, what this does is it allows a mortgagee to give notice to all subsequent, what are called subsequent encumbrances, which are subsequent mortgagees or lien holders, anybody who's on title behind them. So a first mortgagee would give notice to a second mortgagee, and somebody who has a lien, or a third mortgagee, anybody who's behind them in title. What they're basically saying is, I am going to basically acquire ownership of this property pursuant to my foreclosure rights. And if basically, if you have any interest in protecting your interest, as in a second mortgagee or a lien holder, you have the right to pay me off. But if you're not going to pay me off, as in basically replace me in my position as a first mortgagee, then I'm going to eliminate your right as a second mortgagee or a lien holder. Right? It's not used a great deal, but it does happen, and it is used in times where the values of property are exponentially increasing as a function of the market. So some mortgagees will try to take advantage of this, because if they can basically convert the value of their mortgage debt into owning a piece of property that its market value has accelerated greatly, then that may be worth something that they might pursue. But again, far and away, apart from that kind of scenario, the most common way to basically, basically be paid back on a mortgage action is by way of a private power of sale. You can also use personal property as security. Right? So again, you're talking about chattels and goods that can provide security for a loan. We talked a bit about this in a previous class. So you can borrow money against a chattel, that'd be a car or a boat, basically, and you can do that by way of what's called a chattel mortgage, right? Which is in writing and it's under seal. And again, if the debtor defaults in paying the terms of that chattel mortgage, then the lender who basically holds that chattel mortgage will take possession of the property. So that is called, in most circumstances, a conditional sale. For instance, if you buy a car from General Motors and you don't have, the $30,000 to buy the Ford Escort, then you take whatever money you do have that is acceptable to General Motors Acceptance Corporation. That's their lending arm. They will basically allow you to buy the Ford Escort with whatever amount of money they agree to that you provide in cash, and then they will give you a chattel mortgage, right, which is called a conditional sale agreement, with that Ford Escort for the balance. So for instance, if you're buying it for $30,000 and you have $2,000 in cash, they may well give you a chattel mortgage for $28,000. And if you don't make your payments on that chattel mortgage, or which again is called a conditional sale agreement, if you don't make your payments in accordance with whatever that agreement sets out, then General Motors has the right to repossess your vehicle, and they'll resell it under the terms of the mortgage or the conditional sale agreement, and say they only get $22,000 on resale, which means that you still owe them $6,000 on that mortgage debt, that conditional sale. They'll come after you for that deficiency. That's just the way they work, all right? Again, conditional sales are a little bit, the only difference between conditional sales and chattel mortgages are that in conditional sales agreements, the chattel remains as the title, as in the owner, in the title of the person who's selling the property. A chattel mortgage, the title actually transfers to the owner and the mortgage debt goes on top, but they're treated exactly the same with respect to security for personal property. Because the loan for the personal property doesn't change possession of it, it's incredibly important that anybody who may well be acquiring a personal property from somebody else, they need to know if, in fact, again, very much like real estate, if they're getting a good and clear title to that personal piece of property. And the way that they do that is basically they search for that title. So the common law position is essentially this. If a bona fide, which means a verifiable and reliable purchaser, buys a chattel for consideration, you all know what consideration is. If they buy it and they don't have any notice of any other security interest when they buy it, then they obtain title to that chattel, that piece of personal property, without any claims by anybody else. So they get good and clear title to it, right? So that's the position at common law. But in order to address that kind of scenario, what's happened is that most jurisdictions have put into place a registration system, not unlike the registry system or land titles. They put in place a personal property security system that gives notice to people buying personal property if in fact there are chattel mortgages or conditional sale agreements against that personal property, right? And in Ontario, it's called the Personal Property Security Act, which basically sets out a registration system for all security interests in any type of good or chattel in the province. So again, if you do buy that Ford Escort from GNAC, right, you will basically obtain title to that car subject to the mortgage or the conditional sale agreement. And if you were going to sell that Ford Escort to somebody a year or two down the road, when they go to buy it, they're going to go to the registry system. It's online for the what's called the PPSA, the Personal Property Security Act system. They will go online. They will look up. Usually, it's the VIN, the vehicle identification number of the car, or they can look up your name, and all security interests that you have entered into are going to be online. They will look that up on the PPSA system, and they will see if in fact there are any chattel mortgages, liens, or otherwise against the vehicle they're buying. So they'll see the Ford Escort. They'll see that there is a chattel mortgage for $28,000 against the Ford Escort with GNAC. So if they are buying the vehicle for $25,000 or $22,000, whatever it may be, they're going to say to you who are selling it, who you're selling it to them, you have to get rid of that security interest. And that just makes good sense because you're going to be buying it and hopefully to have a good and clear title. And most particularly, if you want to have that good and clear title, if you don't happen to have that $22,000 in cash to buy this used vehicle, then your bank will likely lend you money to buy it, and they're going to want to have a good and clear title to register their security interest against the Ford Escort when it's in your name. Okay, so again, these searches take place in the county or district in which you reside, because that's where your name is, but it's going to come up online in any event across Ontario under the Personal Property Security System. All right, so thank you, everybody. That's the lecture on personal property. Again, on Wednesday at 5:30, I'll distribute the tests for this chapter, chapter 10, in your textbook. And then our next lecture next Monday, which is our last lecture for the semester, is on intellectual property. All right, so thank you, everybody, and see you Wednesday.